To keep yourself updated, subscribe to Indigo Learn and click the bell icon and download our app OneFin to start learning on the go.
Hello dear students, today we are going to be doing the revision of the chapter Indemnity and Guarantee. Now in this chapter, which is from the Indian Contract Act, we have section number 124 onwards till section number 147 that are covered. First we are going to be discussing what is indemnity. In indemnity there are only two sections, that is section number 124 and section number 125. Afterwards, all the sections are relating to guarantee, which is an amazing concept. We are going to be discussing all of those sections. What are the rights of the surety as well as the creditor and the debtor, etc. Right? Let's start off with indemnity first. So what is a contract of indemnity? Section number 124 of the Indian Contract Act defines this contract of indemnity. It says a contract by which one party promises to save the other from the loss caused to him by the conduct of the promisor himself or by the conduct of any other person. Very simple it is. There are two parties involved. One party promises that if there is any loss caused to the second party, then this first mentioned party is going to cover up that loss for this first mentioned party, right? Now this loss may be caused because of two reasons. One is by the act of the promisor or one is by the act of any other person, right? Now these two parties are the indemnifier and the indemnified. Okay, so the person who is being indemnified, the person who is going to get the recovery of the losses, that person is called indemnity holder or the indemnified. Whereas this one person who is saying that if suppose any loss is caused to this indemnified or the indemnity holder, then he is going to repay all of that loss and damage. This person is the indemnifier. Right? Now when we talk about this loss that has to be repaid from the side of the indemnifier to the indemnified, then this loss is repaid only if it is caused because of the action of the promisor or by the action of any other person, third party. Right? Now when we say promisor here, it means the indemnifier. So if suppose indemnifier himself causes some loss to the indemnified, in that case he is going to repay. Or if suppose the loss is caused by any third party to this indemnified, then in that case also it is going to be compensated by this indemnifier, right? Let's try to take up some of the examples to understand this concept of indemnity. The first example is the contract of insurance. Insurance is a contract of indemnity. Let's say I have a car. Okay, now I am scared that when I am going to drive this car, then I might hit this car into something. There might be an accident and my beautiful, wonderful car is going to be damaged. In that case, I can approach to an insurance company and I can ask them to give me an insurance policy, right? Whether this is going to be covered as an indemnity? Yes, the answer is yes, this is a type of an indemnity contract, right? So here insurance company basically says that if suppose my car crashes into something, there is a damage or loss caused to my car, then the insurance company is going to compensate me, right? Now accordingly, I will have to pay some sort of premium to this insurance company for this contract. Right? So now please can you tell me who is the indemnifier here and who is the indemnified here? Well, see here I am the indemnified. Okay, because I am getting the benefit of the indemnity contract, whereas who is the indemnifier here? Here the insurance company becomes the indemnifier, right? Now you have understood what is the meaning of the contract of indemnity. Let's try to understand the basic features of this contract of indemnity. First one is there has to be an existence of a loss. So we had discussed that there are two parties A and B. B is going to Mumbai for articleship. Whatever expenses he is going to incur, A is going to pay, right? But let's say B does not incur any of the expenses. The office is so good that office is paying all of the expenses that are incurred by Mr. B. In that case, is A supposed to pay any of the amount to Mr. B? The answer is no. See, if suppose there is a loss and damage, only then the contract of indemnity comes into picture. Otherwise, the indemnifier does not have to pay any amount. Same way in insurance also, if suppose my car is not broken, it doesn't get damaged, then I am not going to get any amount from the insurance company. So that's the first feature. The second feature is that loss has to be caused by either the promisor himself or any third person. Okay, now that we have discussed already. Now please tell me, is God covered here? Let's say my car is damaged because there is an earthquake. Okay, if suppose any accident is caused because of the act of God. Okay, if suppose there is a disaster, then in that case it is not going to be considered as a contract of indemnity. The next important thing is that all the essentials of a valid contract should be present in this contract of indemnity. So there has to be an offer and acceptance, there has to be an intention to create legal obligation, there should be consideration, parties should be competent, there should be free consent, lawful object, agreement must not be expressly declared to be void, terms and agreements must not be vague or uncertain, legal formalities should be properly complied, agreement must be capable of performance, it should not be impossible. Now please tell me whether life insurance can be considered as a contract of indemnity or not. We have discussed that insurance contract is a contract of indemnity. So in that case, fire insurance, marine insurance, all those will be considered as contract of indemnity. But life insurance contract is not a contract of indemnity. Why? Because here human life is involved, right? If somebody dies, then that loss cannot be compensated in any form, right? So therefore, it is not going to be considered as a contract of indemnity. Next is, what is the mode of creating this contract of indemnity? See, this contract can be created expressly or it can be created impliedly. When we say express, that means there is some sort of communication happening. It is in the form of words. Now, these words may be written or they may be oral, but basically those two parties, they are agreeing to certain terms and conditions. That is express way of making a contract. Okay, so if A and B, they enter into a contract orally or by written form, it is an express way of creating this contract. The other way is implied contracts. Now, when we say implied contract, it means it is coming from the actions of the parties. For example, if suppose there is a principal and there is an agent, between them there is an implied contract of indemnity. Okay, if suppose the agent executes certain jobs which are given by the principal and he incurs any loss or damage, then automatically the principal is going to indemnify him, right? So that is the implied contract of indemnity. Why? Because both of these parties, they are not actually talking this out. They are not actually writing it out. It may be possible that both of them, they don't do it. Okay, they may not talk about it. In that case, it is going to be a contract of indemnity which is implied in nature. The next section is section number 125, which talks about right of the indemnity holder when sued. So if the indemnity holder is sued, if there's a case against the indemnity holder, what are the different damages, different losses, etc. that he can recover from the indemnifier, right? So this section says that any damages that this person has incurred, okay, or any cost that he has incurred in bringing the suit, or if suppose he has to pay any sums in compromise, then all of that will have to be compensated by the indemnifier. Okay. Now, sometimes in the court, there is a compromise situation that happens. Okay. Both the parties are expected to compromise. In that case, if suppose our indemnified has paid some sum according to the court as compromise money, then he can recover that from the indemnifier. When we say cost relating to suit, it means any sort of legal expenses or any sort of lawyer's charges that our indemnity holder is incurring, then he can recover all of those expenses also from the indemnity provider, which is indemnifier. Apart from that, if suppose any other damages are caused to our indemnity holder, that can also be recovered by the indemnifier. But here there are some conditions which we have to remember. See, whatever expenses the indemnity holder is incurring, they should be as per the directions of the indemnifier. If suppose the indemnifier has given some directions and this person is actually following all of those directions, and then this person incurs these damages or other expenses or costs, then he can recover all of them from the indemnifier, right? If there are no such instructions, or if this person goes beyond those instructions and incurs certain expenses, then indemnifier is not going to be liable. For example, let's say A tells B that listen, you go ahead, you file a suit against whatever XYZ people are there, whatever expenses you are going to incur, I am going to repay you all of those expenses. This is an indemnity contract. A is the indemnifier here and B is the indemnity holder here. Okay, A is telling B that go ahead, file a case against these XYZ people, whatever expenses you will incur, I'll pay them. But here let's say Mr. A lays down a simple condition that with respect to lawyer, please hire Mr. X because X is really good, he is my friend, he is going to charge less. Okay, so this is the instruction given by A to B. Now let's say this Mr. B goes ahead and he hires Mr. Y as the lawyer. Y is very expensive. In that case, do you think A should compensate B? The answer is no. Why? Now here in this case, Mr. A is not going to be liable. Why? Because A specifically told Mr. B to go ahead and hire Mr. X, and still B went and hired Mr. Y and incurred additional expenses. So therefore, here Mr. A will not be liable to pay all the amount. Why? Because the instructions were not properly followed. Now when does the liability of the indemnifier commence? The answer to this is when the amount becomes absolute and certain. At that time, the indemnifier's liability commences. What does this mean? Let's say we have A and we have B. Now A has told B, go and file a suit. Whatever expenses you are going to incur, I am going to repay that. Right? Let's say this is the contract of indemnity. Okay. Now B files the case. Now court has decided that B is at fault and B will have to pay some damages. Okay, so here B has incurred some damages, but let's say that the court has not decided the amount of the damages. The court has still not finalized the amount that B will have to bear. Okay, so here definitely B will have to bear some damages, but the amount is not clear. So here, do you think B can go to A and ask for the money? The answer is no. Here A's liability has not yet been established. Okay, A, who is the indemnifier, his liability is going to be established when, first of all, there has to be a loss, and the amount of the loss should be absolute and certain. When that happens, then in that case the indemnifier will have to pay. So in this case, whenever the court decides the exact amount which B will have to pay, then at that time A is going to become liable. At that time the liability of the indemnifier is going to start. So that was all about the contract of indemnity. Now let's get to contract of guarantee. Okay, what is a contract of guarantee, by the way? Let's say we have a person, Mr. A. A needs a loan. So he goes to Mr. B. B gives the loan of, let's say, 50,000 rupees. Right? In this case, B may say that, listen, after 3 months, pay me back this 50,000 rupees along with interest. A says, okay, fine, I'll give it to you. B does not believe. B says, listen, I don't believe you. Why don't you get me a surety? Why don't you get me somebody who can take responsibility that in case you don't pay the amount, then that person is going to pay the amount. So in that case, A goes to C. Okay, and C comes and he enters into contract with these two parties saying that he is going to take the guarantee of Mr. A. Okay, so here C becomes the surety. Okay, C is basically saying that in case after 3 months, A does not make the payment of the amount, C is going to make the payment of this 50,000 rupees along with interest to who? To the creditor, who is Mr. B. So this is the simple contract of guarantee. Here we have taken the example of loan, but it could also be some action that is required. It may be possible that instead of loan, here B is telling A to do some action, and in case A does not do that action, then the guarantee will come into picture. Okay, and this surety will take responsibility of the actions of this person. Okay. So this is the entire contract of guarantee. Now let's try to understand what are the features of the contract of guarantee. Before we get into the features, there are 3 parties involved in the contract of guarantee. These 3 parties are the surety, the principal debtor and the creditor. So the example that we discussed, who is the principal debtor, who is the creditor and who is the surety? We have discussed that A has taken a loan from B and for this C has given the guarantee. So here C becomes your surety. Who is the principal debtor? Debtor is the person who has to make the payment of the loan. So here A is the principal debtor and here B becomes the creditor, right? Now in case of a contract of guarantee, as we have discussed, there are 3 parties. Also, there are 3 different agreements between all of these 3 parties. So there is a tripartite agreement. What is this tripartite agreement? Okay, between A, B and C. See, A is the person who has taken a loan from B. So there is a contract of loan involved here, right? Between B and C. C is the surety and B is the creditor. There is a contract of guarantee involved. Okay, so that means in case A does not make the payment, then in that case C is going to step in. He is going to make the payment to B. Right? Between A and C, there is a implied contract of indemnity. That means if suppose A makes a default in payment of the loan, then we know C, who is the surety, he will have to make the payment of the loan to Mr. B. Right? Now once Mr. C has made the payment of this loan along with interest to B, do you think he should recover all of this amount back from this person who is the principal debtor? The answer is yes. Okay, so this is a contract of indemnity which is implied here between the principal debtor and the surety. So if the principal debtor makes a default and the surety has to make the payment, surety can recover all of that loss and damage and the amount paid from who? From the principal debtor. So there is this contract of indemnity here. So now you have understood what is indemnity and also what is guarantee. So let's try to differentiate between the contract of indemnity and the contract of guarantee. First of all, how many parties are involved? In case of indemnity, there are only 2 parties involved, that is the indemnifier and the indemnity holder. In case of guarantee, on the other hand, there are 3 parties involved, the creditor, the principal debtor and the surety. Now what is the nature of the liability? In case of indemnity, the liability is primary and unconditional, whereas in case of guarantee, the liability is secondary and conditional of the surety. What does this mean? See, surety's liability is conditional, it is secondary. That means surety is liable only and only if the principal debtor fails to make the payment. Otherwise, he will not be liable. So that means surety's liability is conditional. The condition here is that if suppose the principal debtor does not make the payment, then only then the surety is going to be liable. Okay, so it is secondary and conditional in nature. Whereas when we talk about indemnity, in that case, the indemnifier's liability is primary and it is unconditional. So that means if the indemnity holder incurs any losses, then first person who is going to be liable is the indemnifier. Next is the time of the liability. Liability arises only in case of happening of contingencies in case of indemnity, and in case of guarantee, liability arises only on the non-performance or of the promise or the payment of the debt. Okay, so in case of indemnity, if suppose there is any loss caused, then indemnifier has to repay, right? In case of guarantee, on the other hand, if there is the debt which is not repaid, or if suppose the promise is not fulfilled from the side of the principal debtor, then the liability arises. What is the purpose of the indemnity contract and the guarantee contract? See, for indemnity, the reimbursement of the loss is the main purpose. With respect to guarantee, providing a security to the creditor, that is the purpose of the contract of guarantee. Okay, now competency to contract. Both the parties or all the three parties involved in this contract of indemnity or guarantee, should they all be competent? Well, with respect to indemnity, both of the parties should be competent, indemnifier and indemnified. Whereas, in case of guarantee, the principal debtor may or may not be competent. The surety has to be competent, the creditor has to be competent, but the principal debtor may or may not be competent. Let's try to understand with an example. So, suppose there is a person Mr. A and another person Mr. B. Okay, let's say this person A, he is a minor. Okay, he takes a loan from B of, let's say, 5 lakh rupees. Okay, in this case there is a surety involved, C also. Okay, now later on, let's say Mr. A fails to make the repayment of this loan. In that case, can A be asked to repay this amount? Okay, in that case, see, the surety is going to come into the picture. C will have to make the repayment of the amount to Mr. B. But later on, can C ask for this money from A, who is a minor? The answer is no. See, in this contract, we have the principal debtor, Mr. A, who is a minor. We have this creditor, who is B, who is given the loan. And then we have C, who is the surety. In this particular case, the principal debtor is a minor. This contract is absolutely valid. This contract of guarantee is valid. But in this case, the minor will not be held responsible. Okay, so in this case, the surety is going to be held responsible. This is a valid contract. So in the contract of guarantee, the principal debtor may or may not be competent. He may be insolvent also, he may be a minor, is going to be absolutely okay. It will not affect the contract of guarantee. The next relevant section we are discussing is section number 128, which talks about nature and extent of surety's liability. So what is the nature of the liability of the surety? The answer is coextensive with that of the principal debtor. Okay, so if the liability of the debtor is changed, accordingly the liability of the surety is also going to change. If the liability of the principal debtor is reduced, then accordingly surety's liability is also going to be reduced. If the debtor is completely let go of, his entire liability is waived off, then the surety will also be discharged. So basically, surety's liability is dependent and it is coextensive with the liability of our principal debtor, right? Let's take an example. So we'll take the same example. A has taken a loan from B of, let's say, 5 lakh rupees and C is the surety. Let's say on the due date, Mr. B says to A, who is the principal debtor, that listen, you don't have to pay the entire 5 lakh rupees, just pay 3 lakh rupees and that's okay. Okay, so in this case, the liability of the principal debtor is reduced from 5 lakh rupees to 3 lakh rupees. Please tell me, if suppose A does not make the payment, then how much will the surety have to make the payment? How much will C have to compensate? So here C, who is the surety, his liability is also going to reduce to 3 lakh rupees. Why? Because it is coextensive with the liability of the debtor. So if the debtor's liability is reduced, surety's liability will also be reduced. Next point is the liability of the surety arises only on default of the principal debtor. We have discussed this. The liability of the surety is secondary and conditional in nature. The condition is that if and only if the principal debtor fails to make the payment or fails to comply with the promise, then only surety's liability is going to arise, otherwise it is not going to arise. Now let me ask you a question. In this particular case, we have A who's taken a loan from B. B is the creditor, A is the debtor and C is the surety. Now let's say A makes a default. In that case, this person B, can he file a case directly to the surety? Is it necessary for B to make sure that he files a case against A only? Is it necessary that the creditor first files a case against the debtor and then the surety? The answer is no. There is no such compulsion. Okay. See here, B, who is the creditor, he has a separate contract with A and C. He has a contract of debt with A and he has a contract of guarantee with C. So in any of these cases, in any of these contracts, here B has a right to file a case. So even before he proceeds against the debtor, he can file a case against the surety. Surety is still going to be liable. Surety cannot say that, why are you coming to me? First you have to file a case against the person who is the debtor. Surety cannot say something like that. Surety is going to be liable. Now let's read up all the different sections relating to guarantee. Okay, first let's read up section number 132, which talks about liability of two persons primarily liable, not affected by the arrangement between them, that one shall be the surety on others' default. Let's try to understand this with an example. So let's say we have this A person and B person. Let's say both of them have together taken a loan from C. So both of these people are debtors in the eyes of C, and C here becomes the creditor. Now later on what happens? A and B, they together in between themselves, they decide that if suppose on the due date A does not have the money, then B is going to compensate, and if suppose B does not have the money, then A is going to compensate. So they're basically going to act as sureties for each other. Now this is a two-way contract that I'm talking, but it may be possible that only A is agreeing to be the surety for B. It may be very much possible, and actually this entire amount is going to B. But in the eyes of C, both of these people are the debtors. In that case, please tell me later on, if suppose on the due date, if there is default on repayment of this amount, can this C, who is the creditor, can he sue any of these parties by saying that you are the surety? Okay, the answer is no. See here, if suppose A is the actual debtor and actually B acts as a surety, then also this is a contract between A and B. There is no such contract of guarantee between any of these parties with this C. So C later on, even if he finds out that one of these parties is acting as surety for the other, he cannot file a case against any of them by saying that you are the surety, you will have to pay the amount to me because there is a default, right? So this is what this section number 132 says. So here the creditor cannot sue the guarantor even if he is aware of the second contract because he is not party to such a contract. Next, what are the types of guarantees? Guarantees can be either specific guarantee or a continuing guarantee. Specific guarantee, it means it is relating to a specific identified transaction, versus when we say continuing guarantee, it extends to a series of transactions. Let's try to understand this with an example. So when we say continuing guarantee, let's say A is there and there is a person B, okay, and there is a shop. Okay, let's say this shop is owned by C. Okay, now this is a tea shop. Every time Mr. B goes to this tea shop, he takes or buys some tea. Okay, but here Mr. B does not have money every single time to pay to this tea vendor. So here this B tells C that, listen, can you give me tea on credit? After every month I am going to clear the dues. So C says, okay fine, no problem, just get a surety. So here A becomes a surety. A says that whatever T transactions happen for which B is not making the payment, I am going to make the payment at the end of the month. Now here there is no deadline fixed, there is no fixed amount fixed, there is no number of months that are fixed. So every month whenever B is not going to pay for the T amount, then A is going to make the payment of this amount. So this here is a continuing guarantee. Guarantee is being given for not just one transaction but for a series of transactions. So this is called continuing guarantee. Whereas if suppose this transaction was a normal loan transaction for a specific amount or a specific transaction or for multiple specific transactions, we would have considered this as specific guarantee. Now let's talk about revocation of guarantee. The first section here which is relevant is revocation by notice, which is covered in section number 130. When we say notice, it means basically the surety is giving information to the creditor that, listen, I'm done with this guarantee contract, I'm not going to take the responsibility of any future transactions, right? So here this is called revocation of guarantee by notice. This can be done. In this case, if it is a continuing guarantee, then if the notice is given, then with respect to future transactions, the liability of the surety is ended. However, with respect to all the transactions that have already happened till the notice is given, they will still prevail. The surety is still going to be liable, right? Let's take an example for this. We had just discussed that A was the surety and B wanted to buy tea from a vendor who was C, right? Now let's say for the month of August and September, B has purchased the tea, okay, and the amount that he was supposed to pay to the vendor of the tea was 1000 rupees for each of the month, okay. But let's say that Mr. B fails to make this payment. So here A comes forward because he is the surety. He makes the payment of this 1000 rupees for August and September to C. Later on he can recover this amount from B. But at this point A is thinking that every time Mr. B does not make the payment, so I don't want to continue with this guarantee. So what he does, A gives a notice of revocation to Mr. C that, listen, I don't want to be continuing as a surety of this person, Mr. B. Can he do so? The answer is yes. See, whenever he gives the notice to the creditor, after that whatever transactions happen with respect to that, he will not be liable. Okay, so here after August and September, if suppose there is a default in October, November, December, then here A is not going to be liable, but A will continue to be liable till he revokes. So he will still be liable for August and September, for which he has made the payment. Now, can a specific guarantee be revoked? The answer is yes, it can be revoked, but it can only and only be revoked if the liability has not been incurred. Okay, so if suppose the liability has not been incurred, till that time surety can back out, he can revoke the liability, he can revoke the guarantee contract, but not after that. Let's take a simple example to understand this. So suppose we have A wants to purchase 5 bags of rice from B on credit. So Mr. B says, I am going to give you these 5 bags of rice on credit, but I want someone to be the surety. So here Mr. A approaches C becomes the surety here. Right, C agrees that I am going to be the surety. If suppose Mr. A fails to make the payment of this 5 bags of rice, then in that case C is going to come into the picture, he is going to make the payment. Okay, now let's say before B supplies these 5 bags of rice, here Mr. C wants to change his mind, he wants to take back his guarantee. Can he do so? The answer is yes. Now this is an example of specific guarantee. Here the guarantee is only with respect to a specific transaction of purchase of 5 bags of rice. Right? Now before the liability is incurred, the surety can back out. He can take back his liability, he can take back his contract of guarantee. However, once the liability is incurred, after that, because it is a specific contract of guarantee, therefore the surety cannot back out. So here, because the bags are not yet provided by B to A, therefore here C, who is the surety, he can back out. But let's say hypothetically, if we change this example a little bit, let's say B has sold these 5 bags to A on credit, and now A is liable to make the payment of these bags. Now in that case, will C be able to back out? C, who is the surety here, can he back out? The answer is no. Why? Because the liability has already occurred on A, who is our debtor in this case. So in case of specific guarantee, if the liability has been accrued, then the surety cannot back out. However, if the liability has not yet been incurred, then the surety can back out. The next type of revocation is of a continuing guarantee when there is death of the surety. This is covered in section 131. Now this operates exactly the same way when the surety gives a notice of revocation. In case of a continuing guarantee, when a notice of revocation is given, then with respect to future transactions, the surety is no longer liable, but with respect to the transactions that have happened, the surety is liable. Exactly the same thing is going to apply here also in case of surety's death. In case surety dies, then with respect to future transactions, he will not be liable. But with respect to all the transactions that have already happened, his estate, his property is still going to be liable, right? So even though the surety dies, his property is going to still be liable to pay for the transactions that have happened before his death, right? Next is the contract of novation, section number 62. This section says that if suppose there is a contract of guarantee, and with respect to the contract of guarantee, some of the terms and conditions are altered, then it results into a new contract of guarantee. Okay, and that means the previous contract of guarantee is completely revoked. This is a very simple section. The original contract is discharged if a fresh contract is entered either between the same parties or between other parties. So let's say there's a person A who's taking a loan from B, and here C is the surety. Okay, so in that case, let's say the loan amount is 5 lakh rupees and there is an interest of 10% per annum. Okay, this has to be paid. In case A doesn't make the payment, who is the debtor, then the surety is going to make the payment here. Simple transaction. Let's say this original contract is altered. Okay, let's say instead of 5 lakh rupees, now the amount that has to be paid, it is changed to 10 lakh rupees. Okay, or maybe the interest amount is changed, or maybe the number of installments are changed, right? So when that happens, that means the original contract of guarantee is also going to be cancelled out. It may be possible that there is a new contract of guarantee which is created between C and B. Okay, C may agree to be the surety for this new transaction also, but it may be possible that he doesn't want to be part of this new transaction. But any which ways, whenever the terms and conditions are changed, then the previous contract of guarantee is revoked. Now let's talk about when the contract of guarantee is revoked by the conduct of the creditor. The first section we are discussing is section number 133, which talks about variation in the terms of the contract. Now this section says that if suppose the terms of the contract between principal debtor and creditor are altered without the surety's consent, then in that case the surety is going to be discharged. Simple. Let's try to understand this with a small example. So suppose we have a person, Mr. A. A wants a job. Okay, so he goes to B to fetch a job. Okay, B says, I'm going to give you a job. The salary is going to be 50,000 rupees per month, but I need you to bring me a surety. In case you do something wrong, I want someone to be responsible for you. So here C becomes the surety. C says that in case something wrong happens, he is going to take responsibility. He will repay the damages and the losses, right? Now, this continues for a few months. After a few months, what happens is that this Mr. B wants to reduce the salary of Mr. A for some reasons. So, he changes the salary from 50,000 rupees to 30,000 rupees. Now, this particular information is not informed to the surety. The surety here is C. Now, here we can see that the contract terms between the debtor and the creditor, they are altered. But is this detail given to the surety? The answer is no. The surety detail, these details are not given to the surety, right? Now, later on what happens is, after this change, maybe after a couple of months, it is found out that A has been stealing money from B. A, who is the principal debtor, he is stealing money from B. Okay, so here B, who is the creditor, he wants to go to C and ask for these losses and damages. Will C be liable? By the way, this is a question from our past exams also. Okay, the names were altered, but exactly the same case came in your past exams. Now, please tell me whether C, who is the surety, is he going to be liable? The answer is, he is going to be liable till the transactions or till the embezzling or the stealing that happened, till the variation of the terms between the creditor and the debtor. Okay, so when A and B, they decided to change the salary, after that, whatever stealing was done, this surety is not going to be liable. But for all the stealing that was done before that, he is going to be liable. So, whenever the terms and conditions of a contract between the creditor and debtor, they are changed, then the surety is discharged if his consent is not taken. So, in this particular case, we know surety's consent was not taken. He was not informed about this change of salary. So, he will be discharged for any future transactions that happen after that change of terms. The next section is section number 134, by release or discharge of the principal debtor. So, if suppose this creditor becomes very relaxed, he says, listen, you debtor, I don't want you to pay any money. In that case, do you think the surety is going to be discharged? The answer is yes. See, we know the liability of the surety is coextensive with the liability of the debtor. So, if the creditor decides to discharge the debtor, then automatically the surety is also going to be discharged. Simple example, let's take. So, A has taken a loan from B of 5 lakh rupees. Okay, and C is the surety here. Right? Now, in this case, what happens? On the due date, Mr. B says, listen, A, you are my good friend. You don't have to pay this 5 lakh rupees back. Just take it. Okay? Now, in that case, A is discharged. Later on, Mr. B goes to the surety C and asks Mr. C to pay this 5 lakh rupees because A has not paid. Now, in this case, do you think C is supposed to make the payment? The answer is no, C is not supposed to make the payment. Why? Because the debtor is discharged, and because the debtor is discharged, automatically the surety will also be discharged. So here C will not be liable. Another part of this section says that if any act or omission is done, the legal consequence of which is the discharge of the principal debtor, then this is also going to lead to surety being discharged. Now, what does this mean? Let's take a small example to understand this. Again, let's see, there is a person A and there is a person B. Okay, now B tells A to construct a house for him. Okay, A says, okay, fine, I'm going to construct the house. This is the amount that I'm going to charge. B says, okay, fine, I'm going to provide you the material to make that house. So, B, who is the principal creditor, he promises that he is going to supply the material. Only when he is going to supply the material, then A is going to construct the house. Okay, here C becomes the surety. C promises that in case A doesn't construct the house, then C is going to bear all the charges. Okay, now this is the simple contract. Let's say now what happens is that this B person, who is our creditor, he does not supply the material for the construction of the house. Now here A is not able to construct the house. A is discharged. Why? Because the material itself is not provided from the side of the creditor. Do you think this is going to lead to surety also being discharged? The answer is yes, the surety will also be discharged. So here basically what has happened is creditor was supposed to do something according to the contract. Creditor did not do that thing, and because of that the debtor is discharged, and when the debtor is discharged for whatever reasons, the surety is automatically going to be discharged. The next section here is section number 135, which talks about discharge of the surety when the creditor compounds with or gives time to or agrees not to sue the principal debtor. So here the creditor basically either gives too much time to the principal debtor, or Here he agrees that he is never going to sue the debtor, or he compounds with the debtor. In all of these three situations, if the surety is not involved, he is not informed, then he is going to be discharged. Okay, let's try to understand this with simple small examples. Okay, so let's say A has borrowed money from B, 5 lakh rupees, which he is supposed to make the payment after 1 year. Okay, surety here is C. Okay, let's say after 1 year, when it is time for B to collect the money from A, then B says that listen, take 1 more year. Okay, don't pay me right now, take 1 more year, that means pay me after 2 years. So here the time for which the payment has to be made, this time has been increased. Now this detail has not been informed to the surety. Okay, now after 2 years what happens is that this person, Mr. A, who is the debtor, he does not have the money, he makes a default in the payment. Now here, can the creditor B go to C and ask for the money? Can he say to the surety that listen, give me the money because the debtor has defaulted? The answer is no. Why? Because the time of repayment was increased and the surety was not taken consent of. Surety did not agree to this extension of the time. So that is the reason why C is going to be discharged. So that is when promise to give more time leads to discharge of the surety. In the same example, let's change the facts. Let's say that after 1 year, this person, Mr. A, is supposed to make the repayment of the loan of 5 lakh rupees to B. But B says, listen, I'm never going to sue you. B says that I'm not going to sue you, Mr. A. Don't worry, we are just going to go and collect this money from your surety, which is C. Okay, in that case, do you think C is liable? The answer is no. If suppose the creditor says that he is not going to sue the debtor ever, then basically they are putting all the burden on the surety. So here surety is going to be discharged as per our section number 135. Similarly, if suppose the principal debtor and the creditor, they compound together. For their own benefit, they are trying to make a fool of the surety. Then also, if it is proved, then the surety is going to be discharged. Now, there are two exceptions to this section. The first one is section number 136. It says that when the agreement is made by the creditor with the third person to give time to the principal debtor, in that case, the surety is not going to be discharged. What does this mean? If suppose the creditor is discussing with some random third person that he is thinking of giving more time to repay to the debtor, do you think this is going to lead to surety being discharged? The answer is no. The surety is only going to be discharged if the creditor and the debtor, they together decide that there is going to be an extension of time and they do not take surety into consent. Surety has not agreed to it. In that case, the surety is going to be discharged. But if suppose this creditor is talking to some random third person only, that he is going to probably give more time to the debtor, then this is not going to be affecting the liability of the surety. The next exception here is section number 137. It says that mere forbearance on part of the creditor to sue the principal debtor or enforce any other duties against him will not discharge the surety. What does this mean? Let's say the creditor is a little too busy, okay? The debtor has made a default and the creditor is right now not in the space to make a case against the debtor. Do you think this is going to discharge the surety? The answer is no. Let's try to understand this with an example. So suppose here A has taken a loan of B for 5 lakh rupees. This loan is repayable after 1 year and here C is the surety. Okay. Now after 1 year, let's say Mr. A, who is a debtor here, he makes a default, he does not have money, he does not make the payment to the creditor B. Okay. Now here B is too busy. So he does not make a case against A. Okay. Now 1 year has elapsed. After 1 year, B realizes that, oh my god, I was supposed to take this 5 lakh rupees from A. I have not even sued him. I have not even asked the surety. So after 1 year, when he realizes this, he goes to C, who's the surety. He tells C that, listen, I forgot, I was too busy, life was happening, COVID was happening. So now that I've realized, can I have the money please? Because you're the surety, A has made a default. Now in this case, can C say, listen, I'm not liable, you extended the time. Can he say that? The answer is no. Okay, so just because the creditor has failed to sue the debtor because of whatever reasons does not mean the surety is going to be discharged. The surety will still be liable. Surety will only be discharged if there is a legitimate agreement between the creditor and the debtor that the time is going to be extended. Not just because the creditor has failed to sue the debtor. The next section is section number 139. It says discharge of surety by the creditor's act or omission impairing surety's eventual remedy. So if suppose the creditor does something because of which the surety is right, the surety's remedy is affected, in that case the surety is going to be discharged. Okay, this section reads that if the creditor does any act or omission to do an act which is inconsistent with the rights of the surety, then surety is going to be discharged. Let's take an example to understand this. We are taking the same example. Let's say A has taken a loan of 5 lakh rupees from B. So here A becomes a debtor and B becomes a creditor. Let's say this amount is payable in 1 year. And let's say that there is a surety C who agrees that in case A doesn't make the payment, then C is going to make the payment, right? Let's also assume that here there is a security also which is given by A to B. This is some asset which has been put on pledge. Okay, so in this case B has two rights. If suppose A makes a default, then this creditor B, he can either sell off the security and recover the money, or he can ask the surety to give the money. Okay, he has two options in that case. Now what happens is, on the due date A fails to make the payment of the money. But let's hypothetically assume that here B, who is the creditor, he destroys the security. Somehow the security or the asset is destroyed. Now in this case, what happens to the liability of the surety? Well, in this case, see, the surety is going to be discharged. Okay, now this may happen after or before the repayment is done. Next, let's talk about invalidation of the contract of guarantee. First of all, we are talking about section number 142. It says that if suppose a guarantee contract is obtained by misrepresentation done by the creditor or with his knowledge or assent, then the guarantee contract is going to be valid. The second section says that if suppose there is a concealment, then also the contract of guarantee is going to be invalid. Now this is given in your section number 143. Okay, so what it basically means is that if suppose some of the important facts are hidden from the surety by the creditor, okay, or by the knowledge of the creditor, or if some of the important facts are misrepresented, okay, they are wrongly represented, in any of these situations the surety is going to be discharged. This contract of guarantee is not going to be valid. Let's take a small example to understand this. We have taken this one example where A is hired by B, okay, and C is the surety. Okay, C basically guarantees that if suppose A is hired, then if suppose A does anything wrong, then C is going to take responsibility and compensate the losses and damages, right? Now let's say here A has a track record of stealing money from different jobs, and here B is aware about this fact, but both of these parties, they have not informed the surety about this thing. Surety thinks A is a good guy, okay, but both of these parties, the creditor and the debtor, they know that A has a track record of stealing money. Okay, now in this case, do you think this contract of guarantee is valid? The answer is no. Okay, here an important fact relating to the contract has been hidden. It could also be possible that the same fact is misrepresented. It may be possible that Mr. A is showed as a good guy, a person who is reliable. In that case, basically the facts are misrepresented. In that case, again the surety is going to be discharged. This contract of guarantee will not be valid. The next important section is section 144, which talks about co-sureties. In case of co-sureties, if suppose the surety has laid down this condition that he will only act as a surety if there are other co-sureties joining in, then if suppose other co-sureties do not join in, then this contract is going to be invalid. This contract of guarantee is not going to stand. What does it mean? Small example here. Let's say A takes a loan from B of 5 lakh rupees, which is repayable in 1 year. Okay. Now here A goes to C. He tells C, please be my surety. Now C says, I'm going to be your surety, but I don't want to be the only one giving guarantee for you. I want 2 more people to join in. So here A says, okay, fine. D is also going to join in. E is also going to be joined in. Basically, the co-sureties will be C, D and E. Okay. Now later on what happens is D does not join in, E does not join in. Okay. So only one person is there, which is C. Now do you think this contract of guarantee is valid? The answer is no. Okay. If the surety lays down this condition that I want other co-sureties to join in, but the other co-sureties do not join in, then this contract of guarantee is invalid. Now let's talk about the rights of the surety. First, let's talk about the rights of the surety against the principal debtor. The first right is right of subrogation, which is covered in section number 140. What does it say? It says that if suppose the surety has made payment in case of default of the debtor, then basically the surety steps into the shoes of the creditor. Basically he becomes the creditor with respect to the debtor. He has all the rights that the creditor earlier had. So if suppose there is a security involved, then that security is going to be handed over with the surety. The surety can sell off that security, Okay, basically the surety is going to have all the rights relating to the creditor if he repays the amount on behalf of the debtor. Simple. The next one is given in section 145, which talks about right of indemnity. We have understood the contract of indemnity. What is a contract of indemnity? It means any losses, damages which are incurred by one party, the other one compensates for it, right? So in this case, there is an implied contract of indemnity between the surety and the debtor. So if suppose the surety makes the payment on behalf of the debtor, if the debtor has made a default and surety has to make the payment, then later on he can collect all of that amount, losses, damages which he has incurred from who? From the debtor, right? So here the debtor becomes the indemnifier and the surety becomes the indemnified. Now let's talk about the rights of the surety with respect to the creditor. The first one is the right of security, which is covered in section 141. Okay, now here we are talking about the rights of the surety with respect to the creditor, the lender. Okay, so if suppose in the initial contract there is a security which is given by the debtor to the creditor, then if suppose the surety has made the payment of the loan, then that security should come to the surety. We had discussed a very simple small example. We had discussed that A had taken a loan from B of 5 lakh rupees for 1 year and C is the surety in this case. Okay, now in this case A has also given an asset on security. Okay, now let's say on the due date A fails to make the payment. So accordingly C will have to make the payment. C is the surety here. Let's say C makes the payment to B. Does that mean that C can now have the security? The answer is yes. Okay, so here B, the creditor, he has received his entire money, so he will have to hand over the security of the asset to the surety. So now surety will have the right to use the security. If he wants, he can sell that security off also, right? The next is the right to set off. So this means that if suppose between the creditor and the debtor there is some set off that happens, then the surety will get the benefit of that set off. Let's try to understand this with a small example. So let's say A has taken a loan from B of 5 lakh rupees for 1 year and here C becomes the surety. Now let's say on the due date A is supposed to make the payment of the amount to B of 5 lakh rupees. Let's say here what happens is that A has given some sort of services to B before and these services were of 2 lakh rupees. So B says that listen, you have given me the services, I am any which way supposed to give you 2 lakh rupees for your services. So let's just reduce this loan amount. You have to pay me 5 lakh rupees, I have to pay you 2 lakh rupees. So let's just set off that 2 lakh rupees, you simply pay me 3 lakh rupees. So here A says that okay fine, I am going to make you the payment of 3 lakh rupees. Okay, out of this let's say Mr. A only pays 1 lakh rupees. Okay, and 2 lakh is still pending. Now here, can B go to C and ask for the entire 5 lakh rupees or 4 lakh rupees? The answer is no. See, there is a set off that is happening between the creditor and the debtor. So whatever amount is left, whatever amount is due from the side of the debtor, only that can be claimed from the surety. Right? So that set off amount of 2 lakh that is going to be reduced. This 1 lakh rupees of amount that has been paid, this is going to be reduced. So only 2 lakh rupees of amount can be asked from the surety. So this is called the right of set off. So if suppose a creditor has any right of set off against the debtor, it is going to be transferred also to the surety. Surety will also get the right to set off. Okay. The next important right is the right to share reduction. Very simple right it is. So if suppose the creditor says that instead of paying that 5 lakh rupees of loan, let's just pay 4 lakh rupees of loan. If there's reduction of the liability of the debtor, then that reduction is also going to apply to the surety. That is very simple, right? So if suppose the debtor has to pay 4 lakh rupees, surety will also be liable to 4 lakh rupees of amount only. The liability of the surety is coextensive with the liability of the debtor. Next, let's talk about the right of the surety against co-sureties. What are co-sureties? Co-surety is when there is more than one surety involved, more than one guarantor which is involved. In that case, what is the right of one co-surety against the other co-sureties? It is stated in your section number 146 and section number 147. Section 146 says that co-sureties are liable to contribute equally. So if suppose there is no contract between the co-sureties, then in that case they are going to contribute equally to the liability. Let's take a simple example to understand this. So suppose we have A who's taken a loan of 5 lakh rupees from B for 1 year period, and let's say there is sureties also that are involved. Let's say there are more than one sureties. So let's say there is one C and then D and then E. These are the 3 co-sureties involved. Now between them there is no contract as to how much amount they are going to contribute. Now let's say there is a default on the due date from the side of Mr. A. Okay, now here the sureties will have to make the payment of the amount. So here let's say Mr. C, he pays the entire 5 lakh rupees of amount to the creditor B. In that case, can Mr. C recover that remaining amount from D and E? The answer is yes. This is as per section number 146. It says that in case there is no contract between the co-sureties, then each of them is going to contribute equally to the amount. So here C, D and E, they will have to equally contribute this 5 lakh rupees. So if suppose C has paid the entire amount, he can collect the equal contribution from D and E as well. Now here, if we divide 5 lakh rupees with 3 co-sureties, then each of them will have to pay 1.66 lakh rupees. That is going to be their liability. So that is what is stated in section 146. Let's go to section 147 now. This is also talking about the right of surety against co-sureties. If suppose these co-sureties have a sort of a contract wherein one of them or a few of them, they are limiting the amount up to which they want to take the guarantee. In that case, they will contribute equally up till that amount. Then after that, whoever is remaining, they are going to be contributing equally. Let's try to understand this with the same example that we discussed. Now let's say here C, D and E. In this, C is saying that I am only taking guarantee up to 1 lakh rupees. Okay. Now in this case, what is going to happen? See, in this case, if suppose A makes a default, then up to 1 lakh rupees they are going to contribute equally, all 3 of them, and after that the amount that is remaining, it is going to be contributed equally by D and E. Okay, so up to a specific limit, if any of the co-sureties have specified any limit, up to that amount all the co-sureties are going to contribute equally. After that, whatever amount is remaining, up to that is going to be contributed equally by the remaining co-sureties. So in this case, how is it going to operate? See, in case of default of Mr. A, 5 lakh rupees is to be paid. Okay, so then 1 lakh rupees, 1 lakh rupees, 1 lakh rupees is first of all going to be paid equally by all 3 of them. Then after that, how much is remaining? See, 3 lakh has been paid. Then after that, 2 lakh is remaining. So 2 lakh is going to be contributed 1 lakh by D and E. So with this, we have discussed all the different sections relating to our guarantee and indemnity chapter. I hope you have understood everything.